MillerCoors sells a lot of Keystone Light, more beer than Stone Brewing Company sells altogether, and when they decided to change the logo to separate Key from Stone, well, this dude would not abide. Stone versus Molson Coors. Hello, I'm Frank, and this is Beer Esquire. So last Monday, Stone filed a trademark infringement suit against the second largest beer producer in the United States, MillerCoors, and its parent corporation, Molson Coors. Stone's argument is pretty easy to understand. The Stone trademark is registered. It goes back to 1998, and it gives Stone exclusive rights to market beer and ales using the trademark Stone. Keystone's cans look a heck of a lot like Stone, at least from some angles, and the advertising and especially the packaging don't do anything to dissuade you of the notion that this beer is actually called Stone. Stone argues that Molson Coors is confusing consumers or attempting to capitalize on Stone's good name or tarnish it by introducing these new cans into the marketplace, and confusion is the key here. Trademark infringement is decided on the basis of the likelihood of confusion, whether consumers will look at the goods and be confused about who made them. And that's because trademark law, as embodied by the Lanham Act, is really a consumer protection law. The idea is not to give corporations these eternal rights that they can bludgeon each other with, although they might do that. But the idea is that consumers should have assurance that when they pick up something and they think it's that branded item that they've had before or heard about or whatever, that it is. And in the context of litigation, the likelihood of confusion is a really confusing topic. The courts have issued tons of guidance here in the Ninth Circuit, and this case was filed in the Southern District of California, which is in the Ninth Circuit. There's a freaking 8-factor test. And that's not all. The court says that this is a non-exclusive list of factors for determining likelihood of confusion. And the complaint Stone filed is very much aware of these factors. In fact, you can see a lot of them being specifically hit by the complaint or even brought up in the video. For example, they say in the complaint that somebody emailed Stone and said, "Hey, what's the deal with your new light beer?" Of course, Greg Koch said in his video that Stone would never make a beer like that, which is a little bit of a weird thing to say.
Stone Light. Two words that you would never see together in association with our company.
And some people have pointed out that's a weird thing to say. You're basically suggesting that consumers that know about Stone anyways wouldn't be confused by it. Or it could be that he's complaining about Coors tarnishing the good name of Stone. At any rate, all these other factors are hidden in the complaint. It's sold in the same stores. It says that, in fact, sometimes they even have the same distributor in some state. And then they have some wild ball claims in there that MillerCoors, for example, is trying to steal their goodwill, or that MillerCoors someday soon is going to drop Key entirely from their name and just go with Stone beer instead of Keystone. That seems a bit improbable, but these factors are why they plead them. And because of all these considerations, likelihood of confusion is a very fact-intensive question in trademark litigation. It's not usually decided early on. You can't just file a motion to dismiss that this is a frivolous claim and throw it out. That means that trademark litigation is a very expensive proposition. You cannot reach quick wins based on motions. And for that reason, contested cases are rare. Every year in the country, there's something like 3,600 trademark infringement complaints filed in district courts, and only maybe 1% of them actually go to trial. So most trademark infringement complaints are dismissed with very little action on the public docket. The parties apparently come to some resolution, and a stipulation is filed to dismiss the claims. I took a look at some of the craft beer-related trademark infringement complaints filed in the last year, and about half of them have already been dismissed, and it's not really clear what the outcome of any of these is. So will this be one of the rare 1% cases that heads to trial? It might be. Because although this is fashioned as a David and Goliath thing, Stone has quite a few resources, and obviously Molson Coors does as well, and they may not want to budge, as they often do in these cases. So what is MillerCoors going to argue in its defense? They haven't said a lot. There were just a couple of statements put out. This lawsuit is a clever publicity stunt with multiple cameras, tightly scripted video featuring Stone's founder Greg Koch. Like, did we watch the same video? It looked like a not tightly scripted stoner video. Since Keystone's debut in 1989, prior to the founding of Stone Brewing in 1996, our consumers have commonly used Stone to refer to the Keystone brand, and we will let the facts speak for themselves in the legal process. Of course, Greg Koch anticipated this response, and he says in his video, well, this is not for publicity.
Are we doing this for publicity? No. We figured you ought to know the facts.
And in a limited sense, this is absolutely true. I mean, they've got a non-frivolous complaint, so it's filed for a proper purpose, you assume. But if he means he's not trying to score PR, at least at the same time, that's silly. Of course he is. Companies don't normally advertise their trademark litigation, and the reason is that even though it's necessary for a company to preserve its trademark rights, or they risk losing them over time, by filing suit, they come across as a bully. So there's often a backlash to any kind of enforcement. Actually, this is a great example. Stone itself posted this in response to Lagunitas' suit against Sierra Nevada's IPA branding. And so for the same reason, when Stone was calling up a recently founded brewery in Boulder, Colorado, Kettle and Stone Brewing, and trying to get it to change its name or else be sued, they didn't talk about this. The brewery, by the way, is now called Vindication. And as another example, 2 weeks ago, Stone filed an opposition to a trademark application for Stoneys Brewing Company, which is a revival of a very old brand by the family that originally ran it.
It even had, at one point, its own polka.
Roll up the Stoneys, that is my beer.
Stoneys Beer, the brew that made Smithton famous, is once again back with the original family at the helm.
It's like coming home. My great-grandfather, Stoney Jones, started this back in 1907, and it's come full circle. And myself and an investing partner of mine, John Lacart, we're bringing it back to the family.
So, of course, Stone isn't going to put out a video explaining why they're trying to prevent Grandpa Stoney's family from starting a brewing company in Pennsylvania with the old Stoney's trademark. But this action, on the other hand, they're thinking, yeah, maybe the craft industry gets behind us here, goes against the great Satan, one of the duopolists. But this is all getting a little bit into the weeds. My question is, what the heck is MillerCoors going to argue in defense? And I think this is a big part of their argument. Exhibit A. That's the can we're talking about. It says Keystone. Key isn't like in a tiny, tiny font. It's there right on the bottle. And on the back side, it says the whole thing in smaller letters that you can see all at once. And in its complaint, Stone has used a bunch of pictures of cans that look like they just say Stone and nothing else. And the explanation for that is it's advertising. Like in advertising, there's these perfect bottles of Coca-Cola that are glass and have no barcode and no ingredients list, and they're just perfect and pristine with the logo and nothing else. And that's what these cans are. Because when you look at the actual cans, unless you're using your hand to cover up the name Key, it's right there. It's millimeters away from Stone, and the letters are almost as large. And then I think if I'm MillerCoors, I have a hardest time explaining the stacked boxes that look like they just say Stone, Stone, Stone on the side and nothing else. And I went to a liquor store to try to take some pictures of these boxes, but I couldn't find them. Actually, all of the boxes I found look like what's shown on the Keystone website. And if you look at the graphics, you see that these are actually special boxes. These are for their Hunt the Can promotion. It's basically this thing that Keystone's apparently done since 2011 or so, where around hunting season they have special cans of Keystone that are a different color from the other cans, and then if you get them, you can get a prize if you subject yourself to humiliation on social media. So yeah, I think the boxes look pretty bad, but if I'm MillerCoors, I can argue, well, that's not going to happen again, and we can stipulate to that, and that could be part of a very minimalist settlement. But then there's the question of the advertising. In the advertising, although it always says Keystone, it does say Stone on the can. They keep calling the cans of beer Stones. What's up with that? And I think what's up with that is a second prong to MillerCoors' likely defense, which is Laches. Now, Laches is a legal doctrine that a right cannot be enforced if there was a long delay in asserting the right that has prejudiced the adverse party, that has hurt the opponent, and it's some sort of legal ambush. An accused infringer like MillerCoors only needs to show two things to prove Laches. Number one, that there was an unreasonable delay by the plaintiff, Stone, in bringing the lawsuit. And number two, that they suffer some prejudice. And really, this sort of just collapses onto the first question in many courts. How long is the unreasonable delay? And lots of courts have taken the approach to look to the statute of limitations, and a bunch of cases in California courts and in the Ninth Circuit have found that basically you're looking at 4 years, that if you took longer than 4 years, that there's a good claim for Laches. And that's a problem for Stone, at least as far as Stone wants to assert rights against writing, for example, 30 stones on the packages of beer. And it sure looked like they thought they could assert that right. And that's because MillerCoors has put stones on the packages of Keystone beers for a really long time. I mean, if you look at some of the evidence that Stone cited in their complaint, they talk about a trademark application that was filed in 2007. Coors was trying to get a trademark over the word stones, plural, and the Patent and Trademark Office, the PTO, rejected the application, set back an office action, and in response, Molson Coors didn't send anything, or in other words, they abandoned the trademark application for stones. But the interesting part is if you look at the trademark application, it attached a photo of their packaging, and it says stones. And they'd been using it, according to the application, since at least February 2004. And I think that MillerCoors is likely to bring up another application that Stone doesn't mention in their complaint, and it's one that they filed in 2010. Hold My Stones. They wanted to get trademark for Hold My Stones. Very mature, right? Goes with a mature beer. And that application was not rejected. The examiner actually had it published. And basically, when it's published, there are 2 months for anyone in the public to oppose the application. And Stone didn't quite do that. What they did is they filed a request for more time, and then they filed another request to extend the time, and then they filed a third one, and then at that point the PTO denied it and said, you've already had your allotted 90 days, there's no extraordinary circumstances. So the application then would have been allowed, but for a reason I don't understand, the very next day MillerCoors filed an express disclaimer, an express abandonment of the mark Hold My Stones. I'm not sure why that happened. Maybe Stone had threatened them. But the interesting thing is that Stone definitely knew about the attempt to get this trademark. And although there wasn't a registration given to MillerCoors, they used it. They used Hold My Stones a lot.
Hold my stones.
What's your name?
My name? Yeah. It's Keith Stone. Hold my stones. Hold my stones. Hold my stones. Hold my stones.
And after this, Stone did nothing. For 8 years. So if I was MillerCoors, I'd say that Stone has knowingly allowed Keystone to market individual cans of their beer as stones, and is attempting to unfairly harm them by belatedly trying to revoke that right. And there is a counter to Laches. You can't have Laches if there's willful infringement, and Stone alleges that there is willful infringement. But those arguments strike me as a little bit shakier. You know, although Stone mentions things like Blue Moon and the acquisition of all these other breweries as being examples where Big Beer is attempting to leech off of craft, this sure doesn't seem like that. I mean, it still says Coors right on the can. It's not a Blue Moon kind of product, and although I'm sure there is some fuddy-duddy person out there who might be confused by the beers, not very many people in the marketplace, I think, are going to be duped by this. And so I don't think that MillerCoors is intentionally trying to step on Stone's turf here. So in that case, why did they change? Why did they change their historic branding to Stone? Well, it's a design refresh, and there's this modern trend to make huge logos that are actually illegible on the cans, and you can actually see this with the I guess sort of flagship product of MillerCoors, Coors Light. It bleeds over the edge of the cans, and you can certainly see it in the recent Budweiser products. You can even see it in Coca-Cola. You can even see it in other random stuff. I don't know why that's a trend. Ask a designer. But all this said, it's really hard to know how a case like this ultimately shakes out. And again, that is because trademark infringement is so fact-intensive. I wouldn't bet on this case. If you liked or disliked this video, please tell me about it in the comments below, and feel free to subscribe to this channel. If I make more videos like this, then I will, and then you'll get notice of them maybe. Thank you.